The next case is Robert Kenney versus Heidi Carroll. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. Please keep your voice up and remain behind the podium. You should not use the names of children, minors, and victims during your presentation. You can refer to them by initials like the child. Initials or terms like the child, excuse me. The judges have read your briefs and are ready to proceed when you are. You may proceed.
Thank you. I would like to reserve 5 minutes for rebuttal. I appreciate the opportunity to present my case. I'm respectfully requesting that this court order the lower court to comply with the Kenney 1 appellate instructions and attach an extrapolated worksheet that contains both the highest incomes of the parties for which the record has demonstrated are full incomes. This case is over a decade old, and this is the fourth appeal of the same issue. I am seeking resolution to a child support issue that is based on the modification which was filed in 2011. In April of 2013, a 4-day hearing was held on this modification, and it was granted in a judgment entry dated October 22nd, 2013, which contained an extrapolated worksheet for incomes of over $150,000. In 2013, the case was appealed on various issues, and the appellate court remanded the issue. On January 26, 2015, during the remanded hearing before the late Judge Kovac, it is important to note that father never raised any argument in the court that the court had failed to calculate the child support correctly. Furthermore, he never argued that the analysis needed to occur under Ohio Revised Code 3119-04B. Father never objected to the magistrate's inclusion of income in excess of $150,000 in the uncapped child support worksheet. Father's attorney even stated during the oral argument that the child support had been appropriately determined. And in subsequent briefs, the uncapped worksheets have been acknowledged as accurate that were filed by father through his attorney. Kenney 1 also paid, in Kenney 1, I also paid exclusively approximately $70,000 in child care work-related expenses for our child. I was ordered by the temporary ex parte order in November of 2010 to have this nanny by Judge Kovac. Late Judge Kovac later found that the nanny's salary that she had ordered without my attorney's presence was unreasonable and refused to include even a portion of her salary in the worksheet for child care. On November 5th, 2015, Judge Kovac issued a judgment entry, which was a result of a sua sponte order for which there was no legal basis, which contained 3 capped worksheets, labeled Exhibits A through D. In 2017, following remand, this Court of Appeals in Kenney 1 held, to the extent mother challenges the trial court's use of the $150,000 limit in support of the calculations, her fourth assignment error is sustained, and we conclude that the trial court exceeded its jurisdictions provided by the limited remand when it recalculated support in a manner. Therefore, in summary, the trial court imposed a $150,000 cap limit. Its judgment is vacated, and its matters remanded for trial court to recalculate the child support for years at issue without utilization of the $150,000 income limitation. The continuation of the lower court's failure to follow the remand instructions has created an endless cycle of litigation in which new errors have been induced. In Kenney 2, the late Judge Kovac, in a nunc-pro-nunc, added the error and biased opinion that the parties had agreed on the child support to be capped, when no such agreement ever existed. It's important to note that I was a political opponent at that time. In Kenney 3, Judge Stuckey based his decision on facts and evidence that were not on record, alleging vast familial false presumptions that my parents would pay for our son's education, and Kenney 3 also repeated all the arguments in Kenney 2, including the late Judge Kovac's arguments that the parties had agreed to a cap. The judgment entries of both Judge Kovac and Judge Stuckey in Kenney 1 and 2 included extrapolated worksheets, and this is how they justified that they were complying with your order of the court. On July 2nd, in 2024, the judgment entry for which this case is based upon, the child support was based on 9.5% of father's lower 2012 income. So it simply took the father's income and a random percentage. This court did not instruct the lower court to pick an arbitrary percentage of father's income. It specifically instructed the trial court to recalculate the child support for the years at issue without utilization of the $150,000 income cap. The trial judge's method of calculating the child support based solely on the 9.5% of father's lower income is not statutory or legally supported. The lower court must still follow the guidelines when determining child support as set forth in the Ohio Revised Code 311905, which requires the court to consider both parties' incomes. And this is as supported by case law as well in Bazar versus Barzar and the Ohio Supreme Court AS versus JW, which supports the statutory requirements must be followed in the calculations of the parties' incomes, even when they are in excess of $150,000. Income. Furthermore, a worksheet needs to be included. In Duttrick versus Justrick, the 9th District Court of Appeals held that a trial support decision to ignore a parent's income was unreasonable and abuse of discretion. In this case, my income was simply not included in the final order. And again, as I stated, a worksheet was not included, and in Duttrick versus Duttrick, the combined, which was a case also combined incomes of over $150,000, it's held that when modifying an existing child support order, a trial court must find a change of circumstances has occurred. The threshold test and modifying an existing child support order in the statutory 10% test set forth in 311979A is to apply the test. The trial court must complete a new child support worksheet, recalculating the amount in support of the required based upon the new figures. Without an adequate worksheet, there is no ability to determine if a modification has occurred. The visiting judge also introduced new notions. The father would contribute more to his retirement fund as his salary increased. The trial court also erroneously relied on the fact the father would participate in funding the child's private education and repeatedly recited and referred to father's willingness to jointly fund the child's private education expenses and would equally be shared in tuition, books, uniforms, etc. There is no evidence on the record that fathers ever contributed to the private education. And even in Kenney 3, we have the argument that my parents were going to pay for this, which further extrapolates that their fathers never contributed to the education. The July 2nd, 2024 also ignored again the fact that I paid over $70,000 in work-related child care expenses. Although I know that this appellate court stated that we didn't have to include them in as a line item, it should be included overall when you're considering the award amount. And it should be part of that justification and analysis. The July 2nd judgment entry relied on 3 capped worksheets that were attached to the November 5th, 2015 judgment entry, which was vacated by this court, and which was a result, again, of a ruling that had no legal basis. Again, in Kenney 1, there was no argument by father that the use of an extrapolated worksheet was not a proper method to calculate child support, and he did not argue that the court needed to conduct a standard of living analysis. Therefore, he is foreclosed from continuing to argue these points.
Don't we have some case law that if you don't include that worksheet, that the order is void?
Yes,
And that's what you're arguing here today, that it's void?
it is void. As stated in Cumin versus Cumin, you cannot continue to fail to follow the appellate court's instructions. This is what's created this 10 decades. I mean, 2011, our child currently is 16. This continued miscarriage of justice over the last decade is called an endless cycle of litigation, which can only be ended by a direct order. I respectfully request this court to order the lower court to comply with Kenney 1 and instruct this court to attach an extrapolated worksheet that contains both of the highest incomes of the parties. Thank you.
Thank you. You'll have your full 5 minutes for rebuttal.
Good afternoon. May it please the court, my name is Robert Kenney, and I'm representing myself per se. So, Your Honors, there are 4 assignments that are presented in this appeal. Before I get started, I wanted to call out Judge Rapp's judgment entry dated July 2nd, 2024. He took a very complicated case with a lot of issues, including the child support issue at hand. But he did a great job with the summary of relevant history, and then as well as his findings section, which is from page 5, 6, and 7. And then I wanted to highlight the analysis section on pages 7, 8, and then 9 until actual orders. So, you know, really what we have at hand here is, you know, what the appellate court asked the trial court to do. All right, and like I called out in my brief, the remand instructions from this court instruct the trial court not to order, but to calculate support as a starting point. In our case, you know, based on our salaries for the years at hand.
Right, but doesn't that require a calculation then, to have a starting point?
Yes,
So
yeah, I was getting
then
that.
wouldn't that involve a worksheet?
Yes.
Okay, so there's no, do you dispute that there was no worksheet attached with this one?
No, I'm sorry, I didn't say that.
Okay,
Yeah, so I was getting to that point.
thank you.
Sorry about that. Yeah, but, you know, it was to calculate support as a starting point per RC 3119.04B, and that the statute itself instructs that all 3 elements of RC 3119.04B must be met, okay? And what Judge Rapp, I apologize, in his July 2nd, 2024 judgment entry, he attached Exhibit A, which was our original child support order from 2011, as well as Exhibit B, C, and D. And on page, I believe it's 6, I'm sorry. But anyways, he attached exhibits A, B, C, and D. A was from 2011, and he submitted his exhibits for the calculations in exhibit B, C, and D as part of his July 2nd, 2024 order. Okay. So there are 4 exhibits that is part of the July 2nd, 2024 order. Okay. So with that said, going through assignment 1, you know, the Supreme Court of Ohio repeatedly recognized that the use of the term shall in a statute or rule connotes a mandatory obligation unless other language evidence of a clear intent to the contrary. Moreover, the 9th District Court of Appeals has held that when a statute is written in the conjunctive, the legislature employed the use of the word and instead of the word or, that all elements of the statute must be met. See Hardy versus Wilson, 2006, Ohio 4532. So the requirements of the statute are conjunctive in nature, which require all elements to be present. I argue that Judge Rapp, on July 22nd, 2024, he went through all those steps completely and used the salaries based on what we presented as evidence during those 4 hearing days to calculate the child support numbers. And my argument is it was a starting point, right? So after he got to the starting points for each of the years, as part of his analysis, if you go to page 8, had parents remain married, he starts this argument where he builds on as that starting point, and he gives his reasoning and explanation, and he ties a lot of the key parts of the case together with that, okay? I know Ms. Carroll mentioned about the child care nanny expenses. Again, in the 2013 judgment entry, we were ordered to pay for our own child care expenses, and this issue has already been ruled on by the appellate court in Kenney versus Carroll, 2017, Ohio 354. All right. Ms. Carroll mentioned Judge Rapp's 7/2/24 judgment entry and the use of only a 9.5% calculation. You can read in my brief if you can. He was very specific in our July 25th, 24th hearing that he didn't use that calculation only. Okay, he says it's very clear in my judgment entry how I calculate that. In terms of retirement, again, I mentioned in my brief that we already talked about that in the final divorce hearing, so I refer to the transcripts and all that there. In terms of education, Judge Rapp highlighted many items tied to schooling. One specifically, if parties do not agree on the selection, then defendant Carroll shall pay the full cost of preschool without the assistance of plaintiff Kenney. And then during the trial transcripts, there's a discussion that St. Martin's will provide the tuition scholarship for our minor child, basically the entire time he's enrolled. Okay, so if Ms. Carroll had a problem with that arrangement, she could have filed a motion to modify it any time, and she has not done that since these motions. In terms of the third error, I really feel Ms. Carroll ignored pages 7 to 9, like I just highlighted, when it came to how Judge Rapp, again, calculated child support in that process he used. And then I did want to mention for 4, again, it's just this theme of worksheet. There are clearly defined worksheets in Judge Rapp's judgment entry that he used as a starting point, and then he used pages 7 to 9 in his judgment entry from July 2nd, 2024 to give his argument and his analysis of how he actually reached that final child support number. So the 9.5%, it is not an arbitrary calculation. And then I just want to point out, Ms. Carroll pointed out, this, it's on page 28, 29 of her appellate brief, this 17,644 number. Number one, she used the wrong annual salaries for those calculations, and she did not include the minor child's insurance costs, which we stipulated within those 4 days of hearings as well. So, and she didn't even provide that as part of her appellate brief. And I think that's all I had. So if I could reserve some time for rebuttal, I'd appreciate it.
You don't get.
Oh, I don't get it, okay.
Thank you for
Okay,
your.
thank you.
and you'll have 5 minutes for rebuttal.
Is this yours? Is this yours? Sorry. I think this is just a simple case. We held a hearing in 2013. During that hearing, an order came out in which an extrapolated worksheet was attached. Nowhere during the course of that first appellate process was anything argued that the cost of living expenses weren't accurate, shouldn't be part of that extrapolated worksheet calculation. All I'm asking for is that we go back to the basics. We're back to Kenney 1, in which an extrapolated worksheet based on the party's income should be attached. The 9.5% random selection of only father's income is not statutorily supported, nor legally supported. And the percentage, if granted, roughly calculates to $1,600 more a year in child support. It's not like we're looking at huge balances, we're not looking at a huge increase in child support, but it's a justified amount based on the amount of childcare cost, schooling expenses that I incurred as a parent, and the overall things that that initial trial court reviewed during a 4-day hearing. Thank you.
Thank you. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are also published on the Ohio Supreme Court website. Thank you both for your presentation.
Thank you.
Thank you.